Rise. The President, please be seated. We now resume our session. I would like to invite the co-civil parties lawyers to make your oral submissions. You have 1.5 hours. Thank you. Mr. President, Your Honors, good afternoon to participants, both in the courtrooms and at home. My name is Lajanti. I'm a civil party lawyer. I would like to make my oral submission in response to the submission made by the charged person's team. By the submission of the charged person's group, I would like to make the following points as following, which are related to the facts, historical facts, and to the law, and to the arguments, and to the additional evidence. Due to the serious crisis in 1975 to 1979, which caused the severe crimes during the Democratic Cambodia period. In addition, in 1979, we also had a trial relating to the prosecution of the Democratic Cambodia leaders. And in 1993, regarding the restructuring of the country to be a democratic country, a new government was formed, and the ECCC was established. Subsequently, based on the complaints and the objections of the extension of provisional detention, I would like to raise some issues as following. Regarding the Rule 63(3)(a) of the internal rules, where the co-investigating judges issue a detention order, a provisional detention order of the charged person for the following conditions. A, that the person might have committed a crime in the introductory submission. B, the co-investigating judges consider that necessary to prevent the charged person from exerting pressures on any victim or witness, or to prevent any collusions between the charged person and the accomplices of the crimes committed under the jurisdiction of the ECCC, and also to preserve evidence or to prevent its destruction, to ensure the presence of the charged person during the proceedings, and to protect the safety of the charged person, as well as to preserve public order. In addition, the provisional detention order is a necessary measure to prevent and ensure the charged person of any interference from the victims or witnesses in order to preserve the evidence, to preserve public order, to protect the safety of the person, and to ensure his presence during the upcoming hearings. These orders have been issued and fulfilled according to 63.3.125. The house arrest under certain conditions, which is another form of detention. However, it does not prevent all those issues raised in point 63.3a, especially the condition of preserving public order and to protect the safety of the charged person and to preserve the evidence. The Office of the Co-Investigating Judges provided reasons in their decision in extending the provisional detention regarding internal rule 63A, which the co-investigating judges based on the decision of the pre-trial chamber, which was announced recently. The Office of the co-investigating judges has added more evidence after that decision. For the conditions stipulated in 63B, the Office of the co-investigating judges indicates that the conditions in their decision regarding the appeal, the conditions are not changed. And they also agree with the arguments raised by the pre-trial chamber's decision. And these conditions are also in compliance with the European human rights, which was taken into consideration by the OCIJ for the previous detention, and also the ongoing investigations and the hundreds of interviews of witnesses and the complexity of the case filed. So all these conditions are appropriate and in compliance with the European Human Rights Court. Another point which was raised is in relation to a house arrest. The OCIJ indicated their position that a house arrest is not a form substituting and which is reasonable. That is, comparing the ECCC detention and the house arrest is not appropriate. Another reason, another point raised by the defense counsel regarding due diligence in investigation, and also another point raised by the defense counsel regarding the inculpatory evidence is the burden of the OCIJ. and it shows the conditions in Rule 63A and B that needs to be fulfilled or satisfied. The OCIJ failed to include any material evidence that have been found and that is to believed that the charged person have committed crimes as stated in the introductory submission. The detention at the detention facility is not only a form of detention, and a house arrest under certain appropriate conditions is also another alternative form of detention that the LCIJ should have chosen. A house arrest is also to protect the objectives of the Rule 63B. That is the reasons raised by the Defense Counsel. However, what has been raised, there has been a response by the prosecution that if the conditions in Rule 63A and B are fulfilled, which is based in the decision by the OCIJ with their own reasons. So the OCIJ already confirms the reasons and the conditions stipulated in 63A and B. And also the Defense Counsel does not raise which particular point that has to be satisfied in that rule. Another reason that the OCIJ mentioned in their decisions to extend the detention is related to 63.7, which states that the decision of the OCIJ regarding provisional detention is based on reasons for such extension of detention. All these issues have been raised, and there has been a discussion whether all these issues have any impact or have any or violate the rights of the charged person. Another point, the civil party lawyers used to indicate in their brief in response to the appeal of Mrs. Ieng Sary, in which that appeal was limited. So the submission which was used as a reference, the pre-trial chamber could reject the decisions of the OCIJ if they violate their discretion. And if their decision is not appropriate or not based on existing legal points, that is, if the pre-trial chamber considers the issues, the reasonings raised by the OCIJ, it can decide accordingly. What has been believed in the order of the provisional detention is that, one, there is a reasonable belief that the charged person may have committed the crimes, and for the order on the extension of a provisional detention required. The investigation needs to be done with due diligence in order to ensure a fair trial without unnecessary delay. The first provisional detention order based on the introductory submission, and the OCIJ issue various orders by providing reasons that in relation to witnesses or in finding new evidence, in expediting their investigations. Testimonies from the investigation revealed the people were forced to do labor, the monks were forced to disrobe, and people were mass executed and did not receive any proper medical treatment. In addition, people received torture until they die. The charged person was a member of the Central Standing Committee who attended the zone and sectors meetings regularly, and the investigations required an observer who can confirm the charged person might have committed the crimes as charged. For the long detention is not the cause for the release. Longer detention, that is not a sufficient ground for an order to be released, and it's not also a reason for release at all if the investigation was done with due diligence and also considering the complexity of the case. That is, the OCIJ's investigation has been done constantly and continually, and this is not a delay in their investigation or in their conduct of their investigations. Considering the severity of the crimes alleged for the charged persons and also the complexity of the case has to be taken into account. The co-civil parties lawyers submit that the Criminal Code of the Kingdom of Cambodia, the criminal procedure of the Kingdom of Cambodia states that a person's right is a law, but detention is based on the proceeding. And this is stipulated in the Code of the Criminal Procedure, which is similar to Rule 63A and B of the internal rules. The civil parties lawyers submit that the only priority of all these conditions is for the provisional detentions to be appropriate. I also would like to add that in response to the submission by the Defense Counsel of the charged person regarding his health issue, if we consider the health issue of the charged person here at the ECCC detention facility and the house arrest, I think Here at this facility, the medical treatment and service is more than adequate and better than a medical service at home. And that is my submission. Another point I would like to raise is concerning his safety. If he were to detained under house arrest with the conditions, we can ask whether that house arrest, what is a systematic approach in order to protect his safety and to ensure his presence before the ECCC chambers. So this is a question that needs to be answered, and we cannot find any appropriate answers to this question yet. And regarding his safety, there is no one who can provide insurance if he were to be released on bail that his safety is 100% guaranteed for his appearance before the chamber. Thank you.
The President, I would like to invite Mrs. Other civil party lawyer to make your oral submission. A civil party lawyer. First of all, thank you very much, the President and your honors. Before I let my colleague Zil to continue, I would like to add just a few words concerning the legal arguments concerning the order of provisional detention against charged person Ieng Sary. This order has its justification and is issued according to the existing laws. If you look at internal rule 63.6 of our internal rule, and also article 210 of the criminal procedural code that guide the duration of provisional detention of the charged person, which is the sole discretion of the co-investigating judges when they regard this matter as a necessary means. So it is true that the charged person is detained for the second year, and every one of us is quite familiar concerning the factual events in the democratic Cambodia, which are complicated. Among them, this matter has even make the event worse because the charged person exercised his right to remain silent. Rule 63.7 of the internal rule and Article 201 of the 11, of the Criminal Procedural Code of Cambodia state that if the co-investigating judges would like to continue or extend the provisional detention with reasoned decision, then they are entitled to do so. So in the Criminal Code of Procedure, Article 211 and 205 are also the guidance for co-investigating judges to use to support their arguments, because these articles are consistent with the internal rule, Rule 63. I can submit that what the co-investigating judges have done or performed so far are accordance with the legal guidance, and they have done in relation to the prescription of the regulation, our internal rule, Rule 63. And of course, there have been a lot of discussions concerning the provisional detention, and the co-investigating judges still have clear justification to support the argument. And in the appeal of the charged person, they challenge the decision of the co-investigating judges, claiming that co-investigating judges failed to find reasonable evidence to support such a decision. Actually, the pretrial chamber has already ruled on the matter according to the Rule 63A, which is about 63.3a. There is a well-founded reason to believe that the person may have committed the crime or crimes. So the decision by the pretrial chamber and is clear, and that the decision has been based on the decision made by the co-investigating judges, who also got recent arguments. And the condition in Rule 63.3b, which reads that the co-investigating judges consider provisional detention to be a necessary measure. So I see that the burden of proof that these conditions can no longer be applied to the charged person. For example, the security of the person, or the exertion of pressure to witnesses, or destruction of evidence, so on and so forth. If they cannot be applied, or if the circumstances change, then it is the sole responsibility of the defense counsel of the charged person to prove, not the co-investigating judges, because so far the pretrial chamber has already ruled on those kind of conditions. So in order to solve this issue and to support the provisional detention order and to prove, it is the responsibility of the defense counsel. Regarding the health condition of the charged person, Ieng Sary himself is no longer young. He is old. He is more than 80 years old now. So naturally, anyone of his age is weak, although he stays in hospital or being detained in hospital. It is not different from his condition outside the hospital premises. So I can submit that the co-investigating judges has exercised their discretion legally. The President. I would like next the civil party lawyer to continue.
So, good afternoon, Mr. President, Your Honors, good afternoon to everybody. I will now start with the second part of the civil party, or third part, let's say, co-lawyer's submission related to the question if the detention is still necessary measure in accordance with Rule 63(3)(b) of the internal rules. Your Honours, please let me submit 3 remarks in advance. First, we have observed that the defense of the charged person refers to civil parties in general and assigns behavior of particular civil parties to all civil parties. I would like to reveal that civil parties may share several common interests, but each of them acts in a particular manner and has specific views and concerns. Therefore, generalizing and speaking of civil parties as a homogeneous group does not reflect their variety. Generalizing does not take into account that they are individual and different persons with different approaches. Generalization is misleading. Second, the request of the defense for an oral hearing was based, among others, upon the, I quote, inflammatory arguments of the civil parties that need to be rebutted in public, unquote. This term gives reason for serious concerns. The notation itself is inflammatory and contributes to excite the climate. Therefore, we suggest and invite the defense to return to matter-of-fact terms instead of inciting and to calm down. Third, the defense confuses cause and effect by arguing the, I quote, civil parties rely on their own aggressive and outrageous conduct in threatening counsel representing Khieu Samphan to justify that the charged person's detention continues, unquote. We submit that our joint brief in this appeal is factual and takes only into account recent events to assess the elements of the security of the charged person and the public order. I start now analyzing if the security of the charged person and the public order are at risk in the case of his release or being under house arrest. The defense argues in the appeal that the grounds in the extension order by the co-investigating judges do not refer to current events, but to incidents from 2003, which were directed against the Thai embassy. The defense claims that such events could not demonstrate any tension in the Cambodian society of today in light of an eventual release or house arrest of the charged person. Likewise, the defense criticizes that no facts were submitted to show that the release of the charged person or being under house arrest, the public order, could be disturbed and the safety of the charged person were at risk. We will demonstrate that the defense must fail with these arguments and shed light on the fragile post-conflict situation in Cambodia. On 4th of December 2008, after the appeal hearing against Khieu Samphan, several victims, civil parties and applicants held a press conference on the premises of the court and waited after defense counsel of Khieu Samphan had addressed the press. The aggressive arguments by both defense lawyers requesting the immediate release of their client due to the lack of translation of the entire case file into French incited the victim's side, and both sides exchanged vociferous statements. The tension between the national co-lawyer who was attacked for defending Khieu Samphan and the victim side who claimed for an expeditious trial and getting justice increased to the extent of physical approaches against each other, so that the security staff had to intervene and to accompany the defense outside. This incident highlights several issues. The tension among some victims and some civil parties is very high and can turn immediately into physical attacks. One of the concerned subjects was a request for immediate release of the charged person, besides the delay that could be caused by the defense's demand to get every document, regardless of its nature, translated into French. The anger was directed against the defense counsel, who is only acting on behalf of the client and is not charged with allegedly having committed gross atrocities. The national co-lawyer was also beside himself with anger and had not the necessary distance to calm the situation. Instead, he shouted back. So, this incident demonstrates well that the sufferings of some victims, which were buried for a long time, become more and more strongly since the ECCC are operational and proceed with their work. The slightest provocation can amount to verbal and physical aggressions and attacks even against defense lawyers. However, it is not far-fetched to state that the feelings of anger were more intensive against the charged persons. Even if this incident occurred in the case of Cusampon, it can be brought forward to the cases of the other defendants. To conclude and to make it clear, civil party co-lawyers and many of the civil parties uphold that lawyers never should be identified with their clients and the crimes those are charged with, and should work freely and without any threats on their cases.